Hey, I'm Stephen Page from Page, Provan Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law podcast. Thank you for joining me. Today I'm talking about non-responsive and posthumous retrieval, storage and use of sperm, eggs and embryos in Queensland. This is a remarkably complex area, but I'll start with this proposition. Your husband has just died and you want to use his sperm. You have a short window of opportunity to use that sperm, and the thinking by many is that what you've got to do is to get a lawyer and go to the Supreme Court to get an order to allow the retrieval. Well, no you don't, and no you shouldn't. What you should be doing instead is looking at relying on the provisions of the Assisted Reproductive Technology Act, which is you as the widow authorising the retrieval. This has been a significant reform, and it was one that I pushed for prior to the enactment last year. It doesn't matter whether the body is in a hospital or in the morgue. You are the one to authorise, and if in some circumstances you are incapable of doing so, if there's special circumstances, then someone else can authorise on your behalf, a member of your family. That authorisation can occur pre-death if it looks like your husband is not able to recover. And that again is a major change. The doctors have to sign off on it. There's been some difficulty I've seen with doctors signing off on it, so we'll see how that goes. But that change came about from my lobbying and my representations, and that in turn came about from a case some years ago where a doctor approached me and said that there was a man who was not going to recover. He was unconscious, in a coma, and he wanted to be able to retrieve now as opposed to when he died in a few days' time. His view was that as the body lay there, the quality of the sperm would deteriorate, with the result by the time it was lawful to retrieve, there would be no sperm, no viable sperm that his widow could use. I looked at it, the hospital lawyer looked at it, there was no lawful basis then in which he could retrieve. So she had to wait until her husband had died. And what was the outcome? There was no viable sperm. I was determined at that point to make sure that no other widow goes through that, and I'm delighted that the then government listened and as a result put this provision into the Assisted Reproductive Technology Act. At the moment, after the retrieval occurs, then usage is determined by the National Health and Medical Research Council ethical guidelines, which say, in essence, there must not be an objection by the deceased, and that also applies to the retrieval, to the use of the sperm, and the use must be by the widow or partner to the use of the sperm for their own reproduction, and their requirements for counselling, information and a cooling off period. That is the current situation, and this video was recorded in June 2025. By 1 September 2025, that will change. From that time, there will be provisions under the Assisted Reproductive Technology Act governing that usage, the approval for usage. It should be about the same, but we are relying on regulations. Those regulations have not yet been published, even in draft form, and I'm waiting to see those. But I expect, as currently occurs, there will be a requirement for an independent authority to approve the use, At the moment, typically it's done by an independent fertility counsellor who is properly briefed. I hope it's the same system, but I won't know until I see those regulations. No doubt I'll be talking about it in yet another video. Thanks for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers, and this is the Australian Family and Fertility Law Podcast.